Your Honor, this is Kim Rosenko with the Law Office of Dean Mead, representing the Economic Development Commission of Florida Space Coast, which I will refer to as the EDC. I'd like to, if I may, give you a brief overview. The EDC is a private not-for-profit corporation that is funded by many sources and works for the interests of private companies.
Subject to Public Records Act, though, right?
No, Your Honor, we contest it is not subject to the Public Records Act.
Are they doing a governmental function?
Your Honor, we believe under the totality of the factors under the SWAB test.
That's a yes or a no?
No, sir.
Okay.
It's the EDC's contention that it is not a public agency under Chapter 119. It's controlled by a board of directors, which directs the CEO. There's no government agency control. The government agency does not control the actions, functions, or employees of the EDC. EDC contests the jurisdiction of the Circuit Court to hear this matter and has filed a motion to dismiss. The action for mandamus is not and never was appropriate in this instance, and is no longer viable as all the documents in the possession of the EDC that relate to the subject matter of the documents requested have been provided to the clerk. All the documents have been provided, Your Honor. We do have several documents that are financial statements that have not been provided. In order to try to expedite these issues, despite the contention that the EDC is not a public agency, we reached out to BlueWare, which is the subject matter of the records that was requested. BlueWare authorized the EDC to release all the documents, and we did so this week to Mr. Ellis, and I just did the remaining 14 emails were given to Clerk Jacobus. The BlueWare attorney had asked that we retain the financial statement and client list, which I have, which I can give to you, marked in a confidential envelope today to review. But although we're here on a motion to dismiss, and we will argue the jurisdictional issues, we
The
believe...
jurisdictional issue twofold. That is, they're in the Public Record Act. This isn't a public record, subject to public records under Chapter 119, and should be in county court rather than circuit court.
Yes, sir.
Tell me about the county circuit court bill.
Your Honor, under the Florida statutes, and I know you're very aware of this, and I've cited in my motion the proper Florida statutes, the circuit court has jurisdiction, generally speaking, for all actions over $15,000. If this is not a proper writ of mandamus, then the circuit court would not have jurisdiction. It would be a county court jurisdiction. And I have cases... Let me read from it if I could, Your Honor. County courts, this is Florida Statute 34.01, and this is found under tab 1 of the binder provided. County courts have original jurisdiction of all actions of law which the matter in controversy does not exceed the sum of $15,000. County courts have jurisdiction previously exercised by county court judges other than vested in the circuit court. This particular public records action under 119, which it originally was just a public records action under 119, there's no special jurisdiction of the circuit court, and because there is no monetary demand, it is a county court case.
The Constitution says that the circuit court has all jurisdiction that's not vested in this county court. You wouldn't vest this in the county court. Article 5 of the Florida Constitution says it, except by general law, it has to be vested by general law, specifically vested by general law in the county court. If it's not specifically vested in the county court by general law, then the county court the circuit court has jurisdiction. I mean, that's what the Constitution says.
You're right, Your Honor, and I'm looking at Florida statutes, and I do have a case. It is a circuit court case, a Lorenz case versus Cohen, 14 Florida Law Weekly Supplement, and this is found under tab 1, Florida Law Weekly Supplement 548A. And this was a case, it was a homeowner's case, and it wasn't solely vested in the county court, but it was based solely on...
That's what the the way you know what county court jurisdiction is you look at the Constitution, and the Constitution says circuit court has jurisdiction if it's not vested in the county court. So there's got to be something that's vested in the county court.
Yeah, we believe it's merely vested by the fact that there's no monetary demand, and it is simply
a matter of equity? Are you saying it's a matter of equity? That is a specific performance of something, it's not in the money damage? Because there's no money damages, so I guess, right?
Correct.
Okay. So we're talking about, since we're not talking about money damages, we're talking about doing an act. And you know, both circuit and county have equitable jurisdiction, but the equitable jurisdiction is vested, that's in the county court, it's not vested totally in the county court. Both have concurrent jurisdiction. So, you know, my real question is, what statute, general law, vests this exclusively in the county court?
There's not one, Your Honor.
That's a default setting when it has to vest. Article 5. Section 5, Circuit Courts, Jurisdiction. The circuit court shall have original jurisdiction not vested in the county courts. Not vested in the county courts. Further, it says, not vested in the county courts in jurisdiction of appeals when provided by the general law, which means the Florida statutes. So if it's an exclusive vesting in the county court, there's got to be a statute that says so. This is not a matter of money damages, so we don't look to that. That wasn't easy. If it's under 15, fine. If it's over 15, fine. But this isn't that. This is a request for records. Anything else on the county circuit deal?
No, Your Honor.
Circuit has jurisdiction. You have another basis for asserting the circuit court has no jurisdiction, and pretty much it is that this is in the public record.
Yes, Your Honor. And we believe that it's not an agency under the totality of the factors in the Schwab case, and there are other cases that have gone forward and analyzed the 6 or 9 criteria that the court must review, and that's a full evidentiary hearing. As I said, we had reached out to BlueWare and asked that the documents been released, and all of the documents have been released, 2 boxes of documents, and the only thing that's retained is financial documents and the client list. We believe the issue before the court is, as you've now said, there is jurisdiction, is merely the public records request, and that has been resolved. All the records have been provided, and we have witnesses here that could testify that all the records have been provided, how they searched the records, and that they have all been provided.
But you just said that some was withheld.
Except for the financial records, which I do. I have an unsealed envelope for you.
Okay, so all the records were not provided.
All the records but those records, correct, and I have those.
And the basis for saying you're not required to do those records is?
Again, when we go through the whole totality of the circumstances.
It's not a public record.
It's not a public record. We're not a public agency.
Are you claiming an exemption? I mean, some of the papers seem to assert there was an exemption.
Correct.
Are you asserting there was an exemption?
The first contention is we're not an agency under 119.
Mm-hmm.
And that if we are deemed an agency under 119, we're contesting that we still weren't a public agency because of the functions done in this particular project. If we are a public agency, then there's several exemptions. They're not related to the official transaction of business. But because the records have been produced, it's our contention, and we're still maintaining we weren't required to provide the records. Still our contention that the only thing that left, Your Honor, because the records have been produced, is the attorney fee issue. And even if the records that have been withheld are subject to the public records request, then there's an exemption. So the court can review those.
Let me ask you a question. Why would there be an exemption if this wasn't a public record?
If it's not a public record, Your Honor. We're saying it's not a public record, but if
why would they create an exemption? Now, you say, look, you're not entitled, you're not part of this deal.
Who,
the exemption statute. The
right.
Exemptions you're claiming.
Right.
Do you think that matches up that, well, this isn't a public record, then why would they have exemptions in regard thereto?
Well, but it's case-specific factors and circumstances. Every case is unique and distinct. When you look at the case law that talks about the totality of the circumstances and factors, they're all over the board. I mean, you can never tell what a court will do by reading the cases because the court has to determine based upon the evidence and testimony before it. So we first say we're not a public agency, and BlueWare specifically asked us not to give these financial documents. So we have them. But if the court finds that the EDC is a public agency and these records are public records, the financial information and client list, then the exemptions would apply. So it's a quite complicated pyramid to get to the ultimate decisions. That's why, in the interest of judicial economy, we believe that the court should look at the attorney's fees issue, and if the court wants to look at those records that we claim are not public, their financial information.
The attorney's fees issue. They'd have to show unlawful refusal.
Correct, Your Honor. And the case law that we have read says that if you're a private company, even if you're acting as a public agency, you have to unlawfully refuse. And the case law really does not find ever that these private companies have unlawfully refused. Especially the testimony would show the EDC relied on the county attorney's opinion and their own legal counsel in withholding those documents. Now they've all been released.
If they were not a public agency, why did they seek legal assistance from the county attorney?
They sent an email to him because
Why would they render legal assistance if they were not a public agency?
I believe the county was put in a position between the clerk and the EDC, and there was the FDLE investigation which prompted the response from Mr. Knox.
Your motion to dismiss, with regard to this attorney's fees issue, I understand that. If there's an unlawful refusal of a public record request, there is a right to attorney's fees, right?
Correct.
Okay.
If we're a public agency.
That's right. So the attorney's fees issue is kind of the tail of the dog. We will decide that after we decide whether or not it's a public record. There was two other grounds in your motion to dismiss too, I think.
One was that mandamus is not the proper remedy.
And you may be well-founded in that. We'll talk about that in a few minutes.
And the mandamus petition is not verified. Now, to be honest with you, I couldn't find anything that made it to be verified, but my understanding of how the mandamus law works is if they come to you ex parte, they don't have to be verified. Now they're here before you and they have witnesses, and so they would come to you with their petition, ask for the mandamus, that you would issue it like an order to show cause, and then we would have the chance to answer it. We haven't had a chance to answer it in this proceeding. So, one, we don't think mandamus is appropriate, and we're here only on the request for public records. All the alleged public records have been provided.
Okay. Your motion to consolidate was to consolidate this case down to county court, and that's the jurisdictional deal, right?
Right.
Yeah. That motion's denied.
Right, I understand.
Let's have briefs on whether or not this is a public record. The law. We'll have the evidentiary hearing. And then we also have in the evidentiary hearing, if there is an exemption asserted, the defendant will have to, a putative public agency, okay, would have the burden of proving it.
How many days do they have to respond to that public records request? Is there a response?
I don't think there is a response.
Okay.
They've already responded. You know what the positions are.
Yeah, no, I know what the positions are. That's.
So I just want, once they get the briefs, the memos / briefs on what is a public record, then we have our hearing.
How many, can we set date? I mean, because that's one of our positions is, hey, it needs to be expedited so we can go forward. I mean, can we set a timeline?
That's too low.
Well, no, for the memos to be due.
Oh, how long do you need?
10 days.
How long do you need?
20 days?
How about 15 days?
Can I-
Simultaneous exchange.
If I may clarify, because we can do the memos, we have all the law, but it's based upon the facts. It's almost.
Well, I need to know your respective assertion
Okay.
on the law.
Okay.
Okay?
Do you want me to take my book back, or do you want to?
Sure. Take your book back.
And also, Your Honor, just for the record, we don't believe there is any expediency anymore because the records have been produced, except for the financial statements.
The last word you said?
Except
for?
Yes, sir.
That makes it. Except for. So what happened today? Okay. Who's going to do an order on what happened?
I will, Your Honor.
I find that I have jurisdiction for the reasons asserted in the record. I find the attorney's fees is just an allegation, and we will address that if it's determined there's an unlawful refusal. I denied the motion for alternative writ of mandamus because of this Cochran case. I determined that a public record request under the same Cochran case is inappropriate, and I gave 5 days to do that to the plaintiff. And then we were having, within 15 days, briefs/memos on the issue of whether or not the defendant is a public agency, subject to 119. Did I forget anything?
It sounded as though you're saying EDC is not a public agency. Can you address that?
Well, we're not a public agency. We're no different than every economic development organizations, and we have, legal statute to prove that if necessary. We're a freestanding private 501c6 corporation. But we do want to make sure that, what happened today is we want to make sure that we clear up everything if there's questions about releasing the files and everything like that. This was unsolicited and uninvited by the EDC. We've been progressing with legal counsel and doing everything reflective of the law, so we want to make sure that we clear this up soon so we can get on to do the business we need to do.
Well, if the EDC withholds records or keeps records privately, don't you think that can be damaging? For example, information about what was going on.
No, it's the course of doing business. When we're as a private agency working with private companies dealing with private proprietary information on something as significant and sensitive as a site location, that's why we have statutes to protect that. Thank you very much.
Even after all this time, you think it's still a big deal to have that information out there?
Well, we're bounded by legal authority. That's the reason. We have to release it. They'll be releasable legally within so much time. The time isn't elapsed yet. We have released the records for that fact because we're given the authority by the other attorney. And so we just have to reflect what's available with the law. We can't do what we want to do. We very much, we're not trying to be obstinate. We want to very much work with the law. We want to get this behind us. It's been unsolicited, uninvited by our part. So, yes.
Do you think that having to release records would affect your ability to draw other businesses here if you...
I've said enough. Thank you very much.
All right,
Thank
thanks.
you.
The EDC saying in court today that it's not a public agency. What do you think about that?
I think that was a little bit of a surprise. They had mentioned that during the last week, that they would come in and claim that they're not subject to the Public Records Act of Florida. Obviously, we don't agree with that. The fact the majority of their funding comes from the county, and it has for over 20 years. They are clearly a public agency, and their records should be subject to public records law.
And when records are withheld, in this case, in the Needelman and BlueWare fiasco, what kind of damage can ensue?
Well, the issue is you cannot get to the facts of the matter. We've been trying to get to the bottom of the BlueWare issue. The EDCs refused to give us any documentation at all. They've always had the option, going all the way back to our first request in January, to give us some of the documents and let us then resolve issues over the final documents. In fact, that was mentioned today, such as financials. Their position since January was that there was nothing there that was a public record. That position shifted this week to the fact that they claim they're no longer subject to public records and never have been.
Yeah.
Very unusual, because even if you look at the county attorney's opinion, it claimed the records were not public because of an ongoing criminal investigation. Now they claim that the records aren't subject to public records at all, which I believe was the judge's point. If none of the records are subject to a 119 request, why do you bother picking here and there?
Yeah, the bottom line is pretty simple, isn't it? The public needs to know what happened here.
Absolutely.
And could you elaborate on that?
And quite truthfully, if you are funded by public money, to a large extent, you need to produce those records as public records. Now, obviously, if you're a small company and take a small amount of money from the county, your books aren't open. In this case, there's an audit clause in the contract with the county that says the records are to be public. There's a clause in the contract with the county that says their records are subject to 119. That's why it was so unusual that they would assert that they're not subject to those records. It's mentioned at least twice in their specific contract with the county.
Yeah, and to almost belabor the obvious, I mean, why do we need to know what's in those records?
Well, as you know, we're going through the ongoing criminal issue with BlueWare, and we're going through a civil issue as well with BlueWare. We're looking to see what was set up when they came in, because part of our civil case revolves around how did they get hooked up with the clerk of courts in Brevard County. Not just the money, but how did the issue come about? And I believe a lot of that will be found in those EDC records.
Do you think the EDC fully vetted Blue?
Oh, absolutely not. I think that's a given that they didn't, and I think they've now come to admit that they didn't vet them. My concern is that EDC is so eager to bring jobs here that they overlook things that they should be looking at. That even if I don't fully vet you, I still should take a look at you with a critical eye and not a friendly eye. I should have an arm's length transaction when I evaluate your company to bring you in. And particularly, we're talking millions of dollars in different exemptions, including money, cash outlay.
Could you explain the next step in this matter as far as you're going to continue to get those records?
Yes, well, what will happen is, they provided records to us yesterday and today. They believe they gave us the last of the records, other than financial and those that should have been redacted or claimed exemptions on. We will come back before Judge Moxley probably in a month or so, and for the most part, we're here to discuss the issue, is the EDC subject to Florida public records law or not? Each side prepares a brief on that. If Judge Moxley rules that the EDC is subject to public records law, then de facto, they had no reason to withhold these records from us for the last 10 months.
This may seem like an obvious question, but why should the average Joe sitting at home care that they could perhaps vet?
It's their money, but it's their money, and over the last 10 years, the county has given $15 million to the EDC, and I think that the public needs to know where their money has gone.